The Prime Minister, in his address, delivered some sweetness and light. Unfortunately, I'm going to turn the light down a little bit. It's going to get a little dark as I traverse this topic of judicial conduct in the Caribbean, its ethical, political, and social dimensions. And I think it's consistent and in keeping with the theme of this year's conference. I would like to thank President Saunders for issuing this invitation to me. And I'm really, really very delighted to be able to address so many judges. Being an attorney at law who really doesn't practice, this opportunity doesn't come very often. And I suspect maybe after my contribution today, it may never come again. But the topic of judicial conduct, I think, is critically important. It's extremely topical. Those of you who are following events in Trinidad and Tobago and around the region know or aware that events, the rumblings, are high on the Richter scale in Trinidad, and there are also minor tremors elsewhere in the region. And it's perhaps a sensitive topic. It is a sensitive topic, I'm sure, and it is perhaps an uncomfortable topic because I think nobody, judges included, I presume, although I've been assured by judges that their skins are thick and that they can withstand any amount of criticism, that it is an uncomfortable topic for any professional to engage in. What I have done is that I have written a rather long paper on this topic, which will be available to you. It's a draft. It is not for quotation, please, but it is available to you, might be available now, I think, perhaps through CAJO, or certainly after this presentation. And it goes into a lot more detail, and it goes into a lot more of the references and so on. So this presentation is really going to be a kind of a summary of that much more extensive paper. I want to start by saying that over the course of the last 30 years or so, there has been a significant increase in what one might call the governance of judicial conduct. We have had guidelines on judicial conduct promulgated or updated in several Commonwealth jurisdictions. And we have to ask the question, why has there been this elevated interest in judicial conduct and in the issuance of these guidelines? These guidelines have been issued even in the developed countries, in the United Kingdom, in Scotland, in Canada, countries where the incidents of misbehavior, if you may want to call it that, have been rather infrequent since maybe even the 17th or 18th century. But in other contexts, I think particularly in the Trinidad and Tobago context here in the Caribbean, we have had many more, I should say, disproportionately more incidents. And I think this too requires some explanation. So we're trying to explain why is it that there has been globally, at least certainly within the Commonwealth, this tremendous increase in attention to judicial conduct, but also we want to try to explain why is it that in the Caribbean context, we have had what seems to me, at least, to be a disproportionately high incidence of judicial controversy, if you might put it that. My basic hypothesis is this. Judges are social actors. They are neither above society, nor are they outside society. Their behavior is influenced by the social and cultural forces operating within their societies. And therefore, we need to examine the society and its cultural dynamics if we want to understand how the judicial system actually functions and how judges actually behave. Our post-colonial republics or constitutional monarchies may not function, I think, in key respects like the English society, whose colonizers gave birth to our societies by force of arms and which were maintained and who maintained order by what was nothing short of institutionalized violence. In other words, the institutions of our justice system are mostly inherited, but how these institutions actually operate is determined by culture. And our culture in this region, it is not English, it is not French, it is not Dutch, it is our West Indian culture. This is the fundamental tension, I think, that I want to explore between the formal rules of the institutions of the judiciary and the guidelines on judicial conduct and the culturally influenced behaviors to see whether or not this tension explains what we observe of judicial conduct in our West Indian territories. Now, I think that's, I'm going to throw some slides up because I'm not going to be able to read all of the quotations that I'm going to be putting up. Let me start by indicating that the litmus test of judicial conduct is the actual or likely impact on public confidence in the administration of justice. That is the test. The test is not whether or not you're a good judge, or you give landmark judgments, or you have reformed the judiciary. The test is whether or not public confidence, public trust and confidence, as stated in CAJO's blurb, public trust and confidence is maintained or increased. And I've thrown up two quotations there, one from Aharon Barak, who was a former Chief Justice of Israel, and importantly, an Australian judge, Justice J.B. Thomas, who wrote in 1988. And I put him up because Justice Thomas, writing a book on judicial ethics in Australia in 1988, is often credited with initiating this whole move and this whole impetus towards instituting these guidelines on judicial conduct. So I hope we can all agree that upholding public confidence is the right test of judicial conduct. But how do we know whether the public has confidence in the judicial system or the judiciary? How do we know whether that confidence is high or low, whether it is rising or declining? And what I've tried to do is to put together some data on this issue that I have culled from a number of different sources, admittedly very imperfect, and I'm going to come to that at the end in terms of what I think that we perhaps need to do and what perhaps the CCJ and CAJO need to do in this regard. The data that we have is sketchy and it is inadequate. So let me start. Selwyn Ryan, who was perhaps the first or probably the only political scientist to address the question of the judiciary, did a survey in Trinidad and Tobago and in Guyana in the year 2000. And you see the results of that on this slide. And it indicated, and Selwyn's conclusion was, that people in Trinidad and Tobago and in Guyana in the year 2000 did not have a lot of confidence in judiciary. So this is going back 20 years. In 2010, there is something called the World Values Survey, which is done in periodic waves, so that there's currently a wave going on now, which is wave 7. A wave lasts maybe about 2 or 3 years. It covers a large number of countries. All of these countries are subjected to the same sets of questions, and some of these questions relate to the questions around people's confidence in the courts. Now, so I want to pause here and point out that all of these things that I'm talking about, that the surveys and the polls are not necessarily talking about the same thing. So we have to be very, very careful. So some people are asking questions about the judiciary, some people are asking questions about the courts, and we'll see that from a methodological point of view we may have some issues around some of that. But that WVS survey only for Trinidad and Tobago was done in 2010. There were about almost 1,000 respondents to that question, and it indicated that in respect of the courts, 31.2% of respondents had quite a lot or a great deal of confidence in the courts, while 44.5% had not very much, and 16.7% of respondents had none at all. So that over almost 60% of respondents in that WVS survey, World Values Survey, for Trinidad and Tobago in 2010 were indicating that they did not have confidence or had very little confidence in the courts. Our next set of data I present is lower down on that slide, which is a set of polls done for Trinidad and Tobago by a polling company, Solution by Simulation, which does these polls for the Express newspaper. They've been doing these polls consistently for the last several years. They're done by Nigel Henry, who was kind enough to give me the data going back to 2011 for his polls. And they ask about confidence in a number of different institutions in Trinidad and Tobago, including the judiciary. And what the data are telling us, his polling data, the sample sizes run like about 500, 400, 500 people, which is a very good sample size, are telling us that in Trinidad and Tobago, confidence in the judiciary has been low. So it's consistent with Ryan's data going back to the year 2000, but has been declining over the course of the last several years. In respect of Jamaica, I have not found as yet a survey of the kind I've reported here for Trinidad and Tobago, or for Guyana, which shall Ryan's result for Jamaica. But the Jamaica Justice System Project report seemed to embrace contradictory positions on the level of public confidence in the judiciary, asserting in that report, which is a 2007 report, that there was widespread confidence in the integrity and commitment of the judiciary, but also asserted that confidence was decreasing and that there was distrust in the courts. This is in the same document. So I can't quite reconcile those somewhat contradictory conclusions. There are other indicators that we can perhaps look at, and these are all coming from sort of global studies. There is the World Justice Project, which looks at the rule of law and computes a rule of law index for countries around the world. And there's a ranking of countries. So we have rankings for Jamaica, Barbados, Guyana, Trinidad and Tobago, St. Lucia, and St. Vincent. They're scoring the rule of law, and there are several components of that index. And three of those components are relevant, I think. One is the question of the absence of corruption in the judiciary. And we do well. All of the countries in the region do well. I have put up the United Kingdom in the last column there as a comparator, and you'd see that in terms of people's perception of the absence of corruption, our countries do well. But in respect of the delivery of civil justice and criminal justice, we do not do very well at all in respect of this World Justice Project Rule of Law Index. That particular survey actually surveys people like attorneys in the various countries. And finally, we can point to the Global Competitiveness Report, which surveys business people. And the Global Competitiveness Report has, again, a number of different components, including what they call an institutions pillar. And within the institutions pillar, there is discussion about two aspects which relate to the question of the judiciary and the justice system. And again, for the 2018 report on judicial independence, Jamaica has a score of 4.8, Trinidad and Tobago a score of 4.5, with a global rank for Jamaica of 38 out of 137, and Trinidad and Tobago 47 out of 137. And we can compare that with the United Kingdom in terms of their score and its rank. And then in respect of the efficiency of the legal framework in settling disputes, we see that Jamaica has a score of 3.5 with a rank of 72 out of 137 countries, and Trinidad and Tobago has a score of 3.0 with a rank of 104 out of 137 countries. There are results for 2019. The Global Competitiveness Report just came out a couple of weeks ago, and that report indicates that our rankings have, in fact, our scores have, in fact, declined in respect of these two particular factors. Finally, I want to note that some commentators have claimed that the results of recent referenda in Grenada and Antigua and Barbuda, which both rejected accession to the CCJ as the final appellate court for these countries, are indicators of a lack of public confidence in the judiciary in the region. And I have quoted there for you President Adrian Saunders himself, and unfortunately, I don't think you can read it very well, but there's also a quotation there from Martin Daly, who came to exactly the same conclusion, that those results of these two referenda indicate that the public, at least in those two countries, have little trust and confidence in the judiciary, hence their rejection of accession to the CCJ. So despite the methodological difficulties and the fact that we may be talking about different things, judiciary, justice system, the courts, when people ask a question about the justice system, for example, it could well be that they're thinking about the DPP and the police and the prisons and so on. And so therefore, one of the things that we need to be doing is that we need to be refining how we get data on this issue on public confidence for the judiciary, and I'll talk about that towards the end of the presentation. Now, what are the issues that give rise to concern about public confidence? Because I think we can establish that public confidence and trust in the judiciary in the region is certainly not very high and is probably low. What gives rise to concerns about judicial conduct? Well, the issues that typically give rise to concerns about conduct are delay, bias, and to a lesser extent, conduct in the court, such as falling asleep, and conduct out of court, right? What I've described as personal conduct. We might laugh at the question about sleeping in court and so on, but actually in surveying the literature on judicial conduct and so on, this seems to exercise a lot of writers on the question of judicial conduct. Our problems are rather more serious than judges falling asleep in court, I assure you. In respect of bias, impartiality is recognized as the bedrock principle of justice, and hence the fundamental principle underlying judicial conduct. Bias can arise from a number of different sources. I'm not going to go into them. You are very familiar with them as judges yourselves and judicial officers. Conflict of interest, political influence, issue bias. Issue bias is an interesting one in surveying the literature, and that is where, for example, a judge may have a particular concern about a particular issue, a particular valid concern. A judge may be concerned about the environment. A judge may be concerned about gender issues. A judge may be concerned about sexual equality. And in those circumstances, that judge may become biased in her own mind in terms of treating with issues which come before her. So issue bias is an important source of bias. Ethnic bias, and the one I want to focus on a little bit is the question of what I call elite bias. And there I have quoted from Lord Newberger, who was a judge of the UK Supreme Court, because we know that in the English context, there has been a long time this concern that judges drawn being male and from Oxbridge and so on would tend to have a certain kind of elite bias, and that could influence them in terms of giving judgments about certain things. And I want to point out or suggest that elite bias is an issue that we have to confront here in the region as well. So, in respect of ethnic bias, though, that issue may be particularly relevant in the context of Commonwealth Caribbean countries. It refers to the notion that a judge of a particular ethnicity would be influenced, let me underscore, unconsciously, may be influenced, so this is unconscious bias, by the ethnicity of the claimants who appear before her, being more favorably disposed to a co-ethnic and less favorably disposed to a litigant or a prisoner from another ethnic group. In these societies, stratified by race and class, ethnic bias may be bound up with class or elite bias. So it's important to understand that elite bias in our context is also going to be wrapped up with the question of what class you come from and what your elite status within the society. Now, apart from delay and bias, there are three other issues that could impact public confidence in the judiciary. There are opinion conflict. I mentioned it. I'm going to leave it aside. This is where dissent among judges comes out into the public domain. I have not found instances of that in the region. There may be, and I would love to be advised if that would be the case. And the others two, which are important to us, are what I've called internal administrative conflict and personal conduct. Internal administrative conflict has to do with matters which are internal to the judiciary, but which spill over by accident or design into the public domain. It is the spilling over into the public domain that is the problem, that may undermine the institutional integrity of the judiciary. The judiciary needs to present a unified face to the society and to the world, and to be mindful of what they say on and off the bench. When internal issues are leaked into the public domain, the public's level of trust and confidence in judges may be eroded. In respect of personal conduct, that refers to the behavior of a judge outside of court and not directly related to any matter before him. This may relate to private activities such as drug taking, domestic violence, sexual harassment, and so on. The notion that a judge's private life should become grounds for a finding of misbehavior might seem far-fetched. After all, judges are people too, and they are entitled to a private life, even if that conduct falls short of or is different from mainstream community standards. But the Australian Judge Thomas, who I referred to earlier, argued that the relevant test is whether or not the judge's conduct adversely affects public confidence. And J.O. Wilson, another Canadian judge who wrote one of the first set of guidelines on judicial conduct in 1980, also commented, as you see there, on a judge's conduct in public. So both of these judges writing in the 1980s are saying, look, your private conduct has consequences. And therefore, you can't claim that because I am entitled to a private life, et cetera, that therefore I cannot be held accountable for that. Their answer is, and this is going back 30 years, their answer is no, you can and you must be held accountable for that. So while Thomas was writing in 1988, and community standards have since evolved because he's talking about promiscuity and so on, what might have scandalized a community in the 1980s might provide little adverse comment today. On the other hand, standards in respect of behavior, such as sexual harassment, have clearly become more strict. The question, therefore, remains open. What threshold of personal misbehavior must be reached to trigger censure or removal from office? And I would point out that the Privy Council in Gibraltar, which is perhaps the definitive case that we refer to, have wrestled inconclusively, in my view, with the question of whether a judge's character constitutes the basis for his removal. Now, let me just turn to the three factors which have impelled this rise of governance of judicial conduct. There are three factors, I think, that are responsible for it. The first is the abandonment of the Kilmer rules in the 1980s by Lord Mackay in the 1980s. The Kilmer rules were instituted in 1950s, and they essentially banned judges in England from talking to the media, although certain judges ignored it, like Denning, for example, who just ignored it and did his own thing. But the Kilmer rules were abolished in the 1980s by Lord Mackay, and he said he left it up to the individual judge to make his own judgment about how he engages with the media. The second factor, I think, that has impelled this move towards the governance of judicial conduct is what Jonathan Sumption, in his very interesting book that he's just put out this year, referred to as the expanding empire of law. Sumption argues that custom and convention, which regulated life up to the 19th century, and when law regulated a very narrow range of human problems, has given way to the contemporary situation where law penetrates every corner of human life, from the welfare of children, the world of employment, human rights, administrative law, governing most aspects of the relationship between citizen and government. And as we have seen most recently, the exercise of certain prerogative powers by the Prime Minister of the United Kingdom in respect of the prorogation of Parliament. Decisions which would have been left to families, to doctors, and to politicians are now placed before judges for adjudication and decision. These judges, though, are unelected and unaccountable. The third reason has been that there has been a global push for greater transparency and accountability in business and in government since the 1980s. In the business world, from which I come and which I've been worked in for the last 20 years, we have had a number of corporate scandals that led to the whole push towards corporate governance. The Cadbury Committee, the Higgs Committee, we have had legislation like Sarbanes-Oxley, all intended to regulate the behavior of business people and ensure that there's ethical conduct in the boardroom. And up to now, I would say that having been on boards for the last 25 years and seen how boardroom conduct has changed, to the point now where in the boards that we sit on in public companies, we go through processes of board evaluations, we hold each other and we hold the chairman of the board accountable, we hold the CEO accountable through a set of formal processes which have been developed over the course of the last 10 years. So the business world has responded. In respect of the politicians, the government, we have had judicial review, we have had freedom of information legislation, all with the intent of holding people who wield and influence power accountable and trying to ensure transparency. In summary, over the course of the last 4 decades, there has been a growing impetus towards greater accountability on the part of those who wield power in society, whether it is in business, in politics, or in the judiciary. Judges had to be made more accountable, but without trenching on judicial independence. The mechanism of judicial conduct guidelines was preferred, buttressed in some instances by legislation, guaranteeing judicial independence, but prescribing carefully the ways in which a judge might be removed. So the point is that the judges have now been caught up in this whole wave of holding anybody and everybody who exercises power, holding them accountable. In the English-speaking Caribbean, we have been subject to those same global forces. We have promulgated guidelines on judicial conduct in almost all the territories that we have looked at, and all of these are based on the Bangalore principles, or they have drawn extensively on the guidelines from places like Canada and so on. But the drive to accountability here has not always been received openly and trustingly by our local judges, who view the efforts to make them more accountable with suspicion of the motivations of the executive and potentially as an attack on judicial independence. Let me turn now to the question of what our societies are like. I've argued that our judges come from these societies. You are part of the society. You grew up here. You've been socialized here. But what really are our societies like? We know that this is not England. This is not the Netherlands. This is not France. This is the West Indies. So what are our societies like? Now, how do we approach this analysis? The way in which I've chosen to approach it is to look at the work of the cultural anthropologists and the comparative sociologists who seek to define certain social and/or cultural characteristics, and using survey methods, assess how these characteristics vary across countries. So there's really a kind of a comparative analysis. So what you're doing is that you're saying, look, these are a certain set of attributes, if you might want to call it that. How do these attributes vary across societies? And then when you measure that, you can then have a picture, if you like, of what the culture of that particular society looks like. Now, the objectives of this work, a lot of this work actually comes out of countries in Scandinavia and so on, interestingly enough, who have been doing this kind of work. The World Value Survey is one such. I've mentioned it before, and I gave you the results from Trinidad from the WVS survey. You may not be able to see that very clearly. But what the WVS survey does is that it maps countries and it locates them in a certain kind of quadrant, if you like. So that the only country that has participated in the WVS up to now is Trinidad and Tobago. And if you see where Trinidad and Tobago is located, we are just outside of the traditional quadrant, and we are well below what is called the secular rationalist quadrant. On the top right-hand corner, you find countries like the Netherlands, like France, and so on. Countries which tend to be more traditional, tend to have a higher incidence of religion. People believe in, yes, people are more religious. People are more ethnocentric in terms of their views. They are more suspicious. They are less trusting, and so on. And this is where Trinidad and Tobago is located. Now, that doesn't locate the whole of the Caribbean. It doesn't locate Jamaica or anybody else. But if Trinidad is down there, you might want to probably guess where some of the other West Indian countries might certainly lie. It suggests that Trinidad and Tobago reflects traditional values as distinct from secular rational values. And while we have progressed beyond survival values, it remains low in respect of self-expression values, which are in the top half of the chart. A specific interest to our purposes here, Trinidad and Tobago, and I'm going to say this slowly and emphasize because it's critically important, Trinidad and Tobago emerges as a low-trust society. A low-trust society. 96.3% of respondents indicating that one had to be very careful in dealing with people. And by the way, economists who have looked at the issue of trust in relation to economic progress and economic development have found that there is a correlation between trust and economic growth and economic development. They found that there is a difference, for example, as lawyers might be interested in knowing, that the way in which people in Scandinavia and Northern Europe write contracts is very different from the way in which contracts are written, for example, in the United States, with the volumes and reams of paper and so on, compared to how they do it in the Scandinavian countries, because those countries are high-trust societies, whereas we tend to be coming from more low-trust societies. The other study I want to refer to is done by Geert Hofstede and his collaborators. And what they did is that they identified 6 dimensions of national culture: power distance, individualism versus collectivism, masculinity versus femininity, uncertainty avoidance, long-term orientation versus short-term normative orientation, and indulgence versus restraint. For their study, we have Jamaica and Trinidad, except that for 2 of those dimensions, we don't have data for Jamaica. What the data, and I've given the data for Trinidad and Tobago and Jamaica and compared it with the United Kingdom, the United States, Norway, Singapore, and New Zealand as being sort of representative comparator countries. What this tells us, or I'm suggesting, what it tells us is that power distance has to do with how people respond to hierarchy within the society. The society might be hierarchical, but people are deferential to power. So that you would see, for example, that Singapore has a high score on the power distance scale. It's a hierarchical society, and it is a highly deferential society. People defer to people in authority, and they accept, most importantly, they accept that deference. In our societies, there is hierarchy, but people are more prepared to contest authority They are prepared to challenge authority. They are prepared to be more egalitarian. Their impulses are more egalitarian than in, say, a country like Singapore. In respect of indulgence, no surprise, Trinidad and Tobago rates the highest on the indulgence scale. We like to party, we like to fete, and I'm sure that if Jamaica was scored there, they would also be scoring very high up there. But you also see that the United Kingdom and the United States also score high on the indulgence thing. Those societies are described as work hard, play hard societies. They work hard and they play hard. So what is this telling us? Trinidad and Tobago and Jamaica do not accept hierarchical order or inequality without justification and are inclined to be more egalitarian. These tendencies are not as strong as, say, in the United States or United Kingdom. Trinidad and Tobago and Jamaica are more collectivist compared to, say, a country like Singapore, but unlike the United States or United Kingdom. And our societies are more masculine. That is, they are more inclined to be assertive and more open to conflict than to cooperation. We are more open to conflict than to cooperation. Those global studies, I think, are insightful, but I don't speak, in my view, to the historical circumstances of our societies which have engendered the cultural attributes in our societies which we now display. They also don't account for the intensity of personal and ethnic or tribal relationships which occur in small societies, nor do they account for differences or variations within these societies themselves. I have made my own attempt at identifying some of these attributes in my latest book, so I should just tell Justice Rajdakhni that my latest book is not Underachieving Society. My latest book is We Like It So, which was published in 2017, which explores the cultural roots of our economic underdevelopment. And there I identify 8 attributes, of which 4 are important, I think, to the question of judicial conduct: ambivalence and masquerade, rules and authority, status and respect, and conflict and cooperation. The others are not, I think, particularly relevant to us. Ambivalence has to do with the fact that we as elite, and I'm talking here specifically about elite ambivalence now, because everybody in this room is part of the West Indian elite. Elite ambivalence means that we are torn, or we may move between 2 standards of behavior: what might be called a metropolitan standard, adopted from the British or French or Dutch colonial past, and a Creole standard, which derives from our survival and thriving in the reality of our local environments. The pragmatic response of the community to colonial oppression and hypocrisy, and the contestation, particularly after independence, for political and social dominance within our post-colonial societies. So the Creole standard approves of Anansi, the trickster, who is able to defeat the system and the odds and to get through by cunning and trickery. We approve of Anansi. Anansi is part of the folklore and part of our folktales that we tell our children, and that there is approval. Why? Because we understand that systemically the system is unfair. And where does that come from? Right? The colonial society was unfair, systemically unfair, and in order for us to get through, we had to use cunning and trickery, and therefore we tend to approve of that kind of behavior. How else do you explain the metropolitan standard values knowledge and appreciation of European classical music or Shakespeare as markers of learning and good taste. The Creole standard may be evidenced by adopting Creole language contextually, which is most often done by politicians. For lawyers and judges, the Metropolitan Standard elevates English jurisprudence and appearance before the Privy Council as markers of success and accomplishment. Where protagonists determine that it is unwise or impolitic to declare their true position or feelings, they may engage in masquerade. That is, they project a position or a behavior which is expedient in the circumstances. Cross-ethnic interactions are prone to masquerade. But because everybody knows that everybody else could engage in masquerade, that leads to the diminution of trust in what others say and do as evidence of their real feelings or their intentions. That's the explanation that I have for the low trust scores that we get in the World Value Survey. So, in respect of status and respect, our hierarchical societies, our positions in these societies are largely ascribed by ethnicity, color, and complexion, and then by wealth. Wealth does not, in our societies, automatically confer high status. Color, complexion, ethnicity. Then, if you have money, you might be able to get through the door. In the post-independence period, the idea of an elite and who is or is not part of the elite has become contested. Prior to independence, everybody knew who the elite was. The elite were the English people who ran the place. After independence, now the question of who is or who is not part of the elite becomes contested. Some people lay exaggerated claims to their lower class roots, even as they enjoy status and privilege. Elite status is conferred more by the possession of proximity to political power and less by education and wealth. And you can see immediately the problem that judges have in this regard, because status being conferred by proximity to political power, to executive power, immediately creates an issue as far as judges are concerned. High status brings respect and entitlement to honors, to privilege, and access to resources such as bank credit, but does not automatically confer legitimacy. While high status also does not confer immunity from prosecution, it could enable the office holder access to resources to delay, to intimidate prosecutors, and to ensure leniency. Rules and authority. Historically, there were one set of rules for the colonial rulers and another set of rules for our subjects. In the post-colonial period, we ostensibly have one set of rules for everybody. But informal processes produce results for the wealthier, the well-connected, the lighter complexion citizen, which differ from the results for the man in the street. There is what I have described as contingent rule following. That is, the rules apply except where it concerns me, or if the person has high status in the society, or if one of my co-ethnics or colleagues is involved. The adaptive response of the man in the street who understands these things very clearly. People in the street understand what's going on. The adaptive response is to resort, as I've said before, to corruption and to trickery. The end result is that in our societies, relationships trump rules. In our societies, relationships may trump the rules. Loyalty to friends, family, and co-ethnics is given precedence over following the rules. Power and authority may be exercised in a heavy-handed and autocratic manner. However, authority can be ridiculed and challenged either overtly and aggressively, leading to conflict and violence, or passively, which produces resentment and sabotage. Resistance to or ridiculing of authority may be punished in an exemplary fashion in ways which are disproportionate to the perceived infraction. Further, in our plural societies in the region, Guyana and Trinidad and Tobago, the exercise of authority, whether legitimate or not, may be interpreted first and foremost through a racial lens. Conflict in these societies is normal and normalized. Citizens are socialized into keeping themselves within their section in the society. People must not get too big for their boots or hang their hats too high, as this may invite others to put them in their place. So let me put all of this all together for you. We have a society in which judges and magistrates are more often than not drawn from and ex officio constitute part of the elite. You are part of the elite. That is, your position and your office automatically confers on you high status in these status-conscious and status-hungry societies. But status and power are open to challenge. As Naipaul observed, power was recognized, but dignity was allowed to no one. Every person of eminence was held to be crooked and contemptible. We lived in a society which denied itself heroes. And Gordon Lewis wrote, social pretensions received short shrift, although that may, of course, does not make them disappear. No social rank, not even that of the governor, is privileged against sharp comment. Judges, I think, are affected by elite ambivalence. They are torn between the metropolitan standards of fairness, respect, and meritocracy, and the Creole standards of contingent deference to power, elite disrespect of the ordinary citizen, and ascription or entitlement based on color, complexion, or class. If that were not true, then you are an alien. In societies where status is conferred by proximity to executive power, judges desirous of recognition and status have a problem, since such proximity brings their independence and impartiality into question. In respect of our citizens are suspicious of and exhibit low trust in institutions and expect that these institutions, the judiciary included, will be biased against them. Citizens may be rebellious and confrontational or display passive-aggressive behavior or trickery where power cannot prudently or directly be confronted. So let me now turn to the question of judicial conduct in the Caribbean. And in doing this research for this, I was absolutely struck and amazed by what Sir Fred Phillips had to say in 1978 in his book on the evolving legal profession in the region. His words were prophetic, and they're there for you to read, and I'll read them. He said, "There can be no doubt that more and more pressure will inevitably be brought to bear on the judicial department in the exercise of its functions in developing countries. The suggestion is not made because of any noticeable change or deterioration in the conduct of judges, but because the pressures of modern life may in time bring about such deterioration. As the pressures increase," Sir Fred goes on to say, "there are bound to be lapses, and judges will, no less than the public, find it useful to have such a reminder of the principles which should govern their conduct. Such a code would in fact be supportive of the provisions of the various constitutions purporting to proclaim the independence of the judiciary and the absence of political control." This is 1978. This is before anybody, whether it was Wilson in Canada or Thomas in Australia, who advocated for codes for judicial officers. So Fred Phillips was saying to us here, I think you will need a code because of the pressures that you will face. I find it extremely prophetic, and I think it has come to pass. So in respect of delay, I'm not going to dwell too much on that. There have been many cases of delay. It is a big problem. Our courts are notoriously slow. The record of disposition is improving, but there have been instances of egregious delay in giving judgments. In Trinidad and Tobago, in Sukar, a case which I commented on in the newspaper some years ago, that case was heard in the year 2000 and judgment eventually given in 2012 after 2 of the protagonists had died. That's just an example. contempt of court, or I should say contempt of the court. We are taught that contempt of court we are taught as law students and so on, that this has to do with preserving the judiciary and so on. And in the case of Ambad, which we're all familiar with, the Ambad case talked about justice not being a cloistered virtue, and she must be allowed to suffer the scrutiny and respectful, even though outspoken comments of ordinary men. Right? But in that Ambad Privy Council case, in the paragraph just preceding this famous quote, which we all know, there is another statement in that case which actually quotes Lord Morris from an earlier West Indian contempt of court case of MacLeod and St. Aubin. What is significant is what that statement says. It says, and I have it up there for you, courts are satisfied to leave to public opinion attacks or comments derogatory or scandalous to them. But it must be considered that in small colonies, consisting principally of colored populations, the enforcement in proper cases, I underline enforcement in proper cases, of committal for contempt of court for attacks on the court may be absolutely necessary to preserve in such a community the dignity of and respect for the court. And of course, that statement, which the Ambad case was heard, among other people, by Atkin and Lord Maugham and so on, they made no comment on this statement. But I reference this because in the Chokolingo case, which comes after independence in the 1970s, and the Chokolingo case is a very clear case of scandalous behavior on the part of the journalist who wrote this thing in the bomb newspaper. It's a tabloid and so on. And I'm sure that if something like that were written today, that our judges would be wise enough to say that ball is passing outside the off stump and let me leave it and let it pass. Right? But in the 1970s, they decided, no, we have to play this. And actually, interestingly, in the Chokolingo case, it was not the judges who raised the case. The case was raised by the Law Society. The case was raised by the society's elite, who said to Mr. Chokolingo, you can't do that. Right? You can't behave in this way. You can't say this about our judges. And they took Chokolingo to they held him in contempt of court, and of course, he was held in contempt of court. But I make that point to show the question of how the elite operated in respect of this matter. The Ramesh Lawrence Maraj matter I mentioned, and I'll pass over very quickly because that was a very clear case in my view of judicial misconduct. In the case of Rees and Crane, so I've now moved on to bias, this is a case which defines how a commission ought to proceed in initiating the removal of a judge. The significance, in my view, of Rees and Crane, of the Rees and Crane affair, is that the public would be entitled to wonder that if judges could fall into the basic error of unfairness in respect of a process involving fellow judges, then due to what it would seem to be emotion, because the Privy Council found that there was no bias, but that there was animosity among the parties. How could they adjudicate fairly in a society characterized by class and ethnic bias and systemic unfairness? In respect of political bias, we don't have too much evidence of political bias, except that I would point out, this was a very difficult thing to prove anyway, but except that I would point out that there have been a number of instances in Jamaica. We had the Panton case in Barbados. We have had situations of politicians moving from the executive into the judiciary. In Trinidad, we have had people moving both ways. We've had people who were former politicians and members of parliament moving into the judiciary. We've had people moving from the judiciary, and 2 days later, they're running for elected office in Trinidad. And that is okay in a sense, except that the question always comes back, what is the impact of that on public confidence? How does the public perceive that kind of behavior? In respect of internal administrative conflict, I cite the very famous situation in respect of Michael de Labastide, who we all know and love dearly as a former president of the CCJ, but he was then Chief Justice in Trinidad, and the contentious case matter that he had in respect of the Attorney General at the time, the said Ramesh Lawrence Muraj, which had to do ostensibly with the executive wanting additional accountability on the part of the judiciary. But what is significant about that case, I think, is the interpretation by the Chief Justice then of that he was being attacked personally by the Attorney General and by the President of the Law Association, both of whom were political figures. All right? The President of the Law Association then was Carl Hudson Phillips, who had been the former political leader of a party in Trinidad and Tobago. We had the situation where the Law Association had to appoint Telford Georges to do a report, which essentially found in favor of the judiciary, and the government appointed its own commission, the Mackay Commission, which reported on the administration of justice. In more recent times, matters internal to the administration of judiciary in Trinidad and Tobago have been ventilated in the public domain. Let me now turn to personal conduct, and there have been several high-profile instances or allegations of conduct amounting to misbehavior or alleged misbehavior warranting censure. Belize has produced two of those cases, Awich and the Mirabux case, which went to the Privy Council and to the CCJ. In Trinidad, we have had the affair in respect of Satnarayan Sharma, who unfortunately passed away a couple of days ago in Trinidad. But what I want to quote for you is the part of the report of the Mustill Commission on the Sharma affair, and I point out that that commission had on it, apart from Lord Mustill, two West Indian jurists, Sir Vincent Flozac and Dennis Morrison, who is here with us. And one would expect that West Indian jurists would have a very good understanding of the society and so on. But even they were shocked by what they saw. And they said, the picture presented to this tribunal almost defies belief. The air was full of rumor, innuendo, and gossip around and across deep political, and we are forced to say, ethnic divides. At least within this narrow field of view, the concept of the separation of powers seems to have been ignored. We need not go on. The picture is troubling indeed, both for Trinidad, for the tribunal, and for the peoples of Trinidad and Tobago. And a mere 10 years later, the judiciary of Trinidad and Tobago has once more descended into controversy. And the words of the Mustill Tribunal, I think, are entirely appropriate to the circumstances that we face in Trinidad and Tobago today. So let me try if I can pull together and draw some conclusions. First, public confidence is low because of historical circumstances within our societies, the way in which our societies were created, characterized by inequality, ascription within status hierarchies, arbitrary punishment as the means of maintaining order, with a concomitant lack of conflict management skills which need to be learned and inculcated from an early age. We don't learn conflict management. We don't teach our children conflict management at an early age. And this is one of the reasons why we tend to see these members of the elite escalating into, quite frankly, to use the Trinidadian word, bacchanal. Secondly, our judges are born into and socialized in these societies and must unlearn the behaviors which typify the elite of which they are inescapably a part. Standards of appropriate conduct are understood intellectually, but may be practiced culturally. Judges in our region have to learn to operate counterculturally. Third, the corporatization is an ugly word, but I couldn't think of a better word. The corporatization of the judiciary is inevitable and needs to be embraced, along with codes of conduct as distinct from mere guidelines and real accountability. Corporatization entails organizational structures which do not derogate from the independence of the individual judge in her courtroom, but locates that judge in an organization which is accountable to society through Parliament for its performance, and goes beyond the ritual ex cathedra speech at the opening of the law term and the annual report to responding to questions of an appropriately selected parliamentary committee through a reconstituted Judicial Appointments Commission. I have seen Baroness Hale and the Deputy President of the UK Supreme Court sitting in front of a committee of the British Parliament answering questions very civilly. We need to be able to do this. They do the same thing in Canada after the appointment of a judge. A specially selected committee of the Parliament of Canada sits down and has a discussion with the Chief Justice about what his or her plans are for the judiciary. So accountability in that sense for what the judiciary needs to do and to deliver is not at all inconsistent, in my view, with appearing before a parliamentary committee, independent senators, in the case of Trinidad and Tobago, and explaining what you are doing about the administration of justice, not about the judgments that you make in your court, but about the administration of justice. It is an organization of written job descriptions and delineation of authorities. It is an organization in which, while judges may speak extrajudicially on matters of law and jurisprudence, only designated officers speak to the media on corporate matters. I have been a director of a number of different public companies. The rule is quite simply, only the chairman and the CEO speak for the company. Because you're a director of the company does not give you the right to talk to the media about what goes on in the organization. And the same has to apply to judges. The Chief Justice speaks for the judiciary on matters related, on corporate matters. We can't have, as we have in Trinidad, puny judges delivering lectures and talking about the economy and all kinds of things. It is an organization where the Judicial Appointments Commission has the means to impose intermediate sanctions, including derostering and suspending judges, to counsel poor performers out of the judiciary, and where needed, to refer judges to EAP-type, Employee Assistance Program-type counseling, all within the confines of the judiciary itself without any involvement of the executive or the legislature. This has to happen. And consider what might have been different in the Crane matter if the judiciary had had an EAP program. Those of you who know the backstory to Crane, if you had had an EAP program in those circumstances. Along with the relevant tests of competence and temperament, aspiring judges should be required to do the Harvard Implicit Association test to test for unconscious bias, ethnic bias. The corporatization of the judiciary will require that it focuses on performance measurement in a serious manner and cascades the overall performance measures down to the performance of the individual judge. There must be regular measurement of public confidence in the judiciary. We need to have a regional project that defines public confidence appropriately and is measured in the same way across our region, that is implemented on an annual basis so that we can keep track of how we are doing in respect of building and restoring public confidence. Fourth, judges must avoid descending into the arena. The myth and mystique of judicial office must be maintained. You were right to dispense with the wigs, but it would be a mistake for judges to comport themselves in our society like if they were anyone else. You don't need to be aloof or stush, as the modern people say, but you have to be reserved in dress and speech and deportment in public, except, of course, when you are in Justice Barrow's house. And I'm saying this, not because I am concerned about the behavior of judges. I am concerned about the egalitarian impulses of our societies. The frequent failure to recognize and respect boundaries will cause people to treat judges as one of the boys or one of the girls, open to casual regard, if not disrespect, and being seen as open to the extraction of favors and the contact, which is part and parcel of life in these small West Indian societies. This is the challenge. How to be reserved without appearing arrogant. How to be part of the social and community occasions without compromising your integrity. Some judges may elect to become reclusive, but that's not optimal. It makes sense for you to choose your friends and associates wisely, friends and associates who understand the constraints you face as a judge and respect the boundaries. And fifth, there's probably a need for greater collegiality among judges. Occasions like this are wonderful. But the work of a judge can be, we know, somewhat lonely, and it may not afford the daily interaction which corporate life offers to business executives. It therefore may not offer opportunities for judges to discuss personal problems and issues with fellow judges and get advice. The judicial conduct guidelines which you have actually speak to this, and to the extent that it is not, it is perhaps needs to be put into practice. The job of a judge is difficult, even in the best of circumstances, but especially in these small, post-colonial West Indian societies. But we have to begin the work of reform, or else we will continue to see the breakdown and erosion of confidence so evident in Trinidad and Tobago, and perhaps elsewhere in the region, with the consequences, dire consequences, for the fragile democracies that we have. I thank you. I completely lost track of the time, so I'm quite sure there's no more time for questions, but I did want to present Adrian with copies of two books. Since Justice Jamana won't give you your gift until you get to Trinidad, I'd like to give you a copy of my latest book, if you like it. So, and also a very interesting book, Judges on Trial by Shimon Shetrit and Sophie Turen, which I found extremely useful in preparing this work. So,
thank you very much.
Okay.